Don't worry. We've just arrived. We've just arrived. Yes, thank you.
Lord, you'd asked me a question about the 2018 directive. I wanted to make sure I rechecked the provision. It does two things. Against the background where the European Parliament is deciding that the types of supplier addresses should have the same treatment because they are comparable situations, that's recitals 1 and 2. Recital 3 does two things. It tells member states that they can introduce reduced rates for books and newspapers that are provided electronically and on physical means of support. That's the newly introduced reduced rates. And it also provides, secondly, that member states that currently have reduced rates or zero rating for books or newspapers on physical means of support are permitted to give the same treatment to electronically delivered editions. And the operative parts of the directive amend Articles 98 and 99 of the principle of that directive, thereby amending the harmonised system. The directive does not make provision for the non-harmonised features of the VAT world, here in the UK, zero rating. Now, the UK made the change in 2020, was during the implementation period. We say it was doing no more than the UK was already entitled to do, and consequently the UK government did not act unlawfully in doing so. But here the chronology may be important. The government announced the change in the budget of 2020, and it was originally going to take effect in December 2020. But with 1 day's notice, that was brought forward, because of coronavirus, to the 1st of May 2020 as part of a package of measures that were designed to be broadly compatible with lockdown. But significantly, at the time that change was made, we were winning in the upper tribunal. The upper tribunal had ruled that newspaper, properly understood, applied to digital newspapers. So as the law then stood, the change was clearly respecting or reflecting what we say is the position even now. And the vires that is identified for the change that was made was Section 30 of the VAT Act, Section 30, subsection 4. So the directive in 2018 doesn't address the situation of member states that had, through a derogation, a zero rating. I was about to turn then to the principle of fiscal neutrality. So thus far, I have looked at the analysis without regard to this principle. We say, for the reasons that I've already advanced, that we are entitled to the benefit of zero rating without regard to this principle. I also say that we're also entitled to that treatment with the benefit of the principle. Now, here I need to address four separate questions. Firstly, what is the principle? Secondly, can it apply in the context of zero rating? Thirdly, how does our case on issue 2 fit with our case on issue 1? And then lastly, if the principle would otherwise apply, are there any other reasons why it should not do so here? First of those, what is the principle? I think I can take relatively shortly. It's a principle that deals with circumstances where you have two supplies that are appropriately comparable, and there is a requirement, as a matter of principle, to ensure that those comparable supplies have a comparable tax treatment. It's a principle that's used in two senses in the VAT world. That's the second sense. The first sense is the idea that the tax should cascade down the chain of production with the recovery of the VAT at the preceding stage to ensure that the tax is ultimately borne by the final consumer. That's sometimes described as fiscal neutrality. We're not concerned with that. We're concerned with its other sense, the requirement to treat like supplies alike. Decision of the Court of Justice in rank is the best expression of the relevant principle itself. The head note in rank is at page 130 in the authorities. Rank concerned gaming machines that were subject to differing VAT treatments in the UK. Rank complained about that. The case eventually went to the Court of Justice. Head notes at 130 and 131. The relevant paragraphs in the decision of the court run from paragraphs 31 through to 36, and that's at pages 141 to 142. Paragraph 32 is noteworthy. It identifies that the principle of fiscal neutrality precludes treating similar goods and supplies of services, which are thus in competition with each other. They cannot be treated differently. So to note, they don't have to be the same, they just have to be similar. And where they are similar, they are assumed to be in competition. And that's made clear by 33. According to that description of the principle, the similar nature of two supplies of services entails the consequence that they are in competition with each other. So you don't need to prove actual competition. Then paragraph 35, that consideration is also valid as regards the existence of distortion of competition. The fact that two identical or similar supplies, note supplies, not suppliers, which meet the same needs are treated differently for the purposes of VAT gives rise as a general rule to distortion of competition. Then it goes on in 36, the court goes on to say that there is a requirement to ensure a similarity of treatment where you have supplies of services which are identical or similar from the point of view of the consumer and meet the same needs of the consumer. So if you've got same or similar supplies, the expectation is they should have the same VAT treatment. Here, on the facts found by the first tier, the tribunal concluded that the print editions were fundamentally the same or very similar to the digital editions, thereby engaging the principle. And prima facie, at least at this stage of my argument, those similar or the same or very similar supplies have a different VAT treatment. Now, two other points to note about the principle itself. There was some debate in the authorities as to whether it was a freestanding principle of European law or whether it was merely a principle of interpretation. The court has answered that in the latter respect, and that can be seen most clearly in a case involving Deutsche Bank. It begins at page 300 of the authorities, but in particular it's the court at paragraph 45, page 324. Paragraph 45, page 324, the court had arrived at a conclusion about the construction of a particular directive. That conclusion is not called into question by the principle of fiscal neutrality. As the Advocate General stated at point 60 of her opinion, the principle cannot extend the scope of an exemption in the absence of clear wording to that effect. So pausing there, you can't rely on the principle to extend the scope of an exemption. Same is true of a zero rating. So principle of fiscal neutrality cannot extend a zero rating, but then relevant to the next sentence, that principle is not a rule of primary law which can condition the validity of an exemption, but a principle of interpretation to be applied concurrently with the principle of strict interpretation of exemptions. What the court is saying there, as the Advocate General had said at her paragraph 60, is that there is an obligation to apply a strict interpretation to exemptions, equally here zero rate, but there is a concurrent principle which requires giving effect to equal treatment of like goods and services. So one is a principle of statutory construction that is a constraint on the other. They have to be applied concurrently. So as a consequence here, translating that to zero rating, you have to give zero rating a strict interpretation, but one that accords with the purposes of the provision, my lord, in SAE education. But concurrently, you need to give effect to the principle of fiscal neutrality, which requires the VAT treatment of like supplies. Now, at this point, I pause to note, which no doubt would be obvious to the court, that there is an artificial divide between issue 1 and issue 2, because once you see issue 2 as a question of interpretation, then it ought to form part of issue 1.
Yes, if you don't get home on issue 1, issue 2 won't by itself.
Well, I need to address that because that's nearly true, but not wholly true.
I see.
But is fiscal neutrality relevant to the interpretation of the UK exemption?
Lord, the answer is yes, and I'm going to show your Lordship why in a second.
Okay.
So let me recognise that there is an artificial divide. We addressed fiscal neutrality separately below, and it's identified as a separate issue here because the principle of fiscal neutrality has its own requirements that are best analysed separately, at least for my part, but ultimately it is a principle of interpretation that in principle has to be factored in on issue 1. So coming in a short moment to the question, what of my case is left on issue 2 if I'm wrong on issue 1, the intermediate question is my question 2, can the principle apply in the context of zero rating? And the answer is yes, because your Lordships may recall that we didn't look specifically at the second VAT directive, but it's also in Article 110. Member States have a freedom to maintain a zero rating where they originally exercised that choice for clearly defined social reasons and for the benefit of the final consumer. But there's another part of that phrase that I've skipped so far, which is it has to be in accordance with EU law. And that requirement that the operation of the domestic zero rating is in accordance with EU law brings with it the obligation to comply with other principles of interpretation found in EU law. And that is right is now clear from a decision of the Court of Justice in one of the many Marks and Spencer's cases. This begins at page 366. This was the case about chocolate-covered tea cakes and whether they were standard rated or zero rated, and it turned out they were zero rated, and then there was a claim to recover the output tax. And one of the issues was, as a taxpayer in the UK, did you have an EU law right to a zero rating? The Court of Justice says no. Then the next logical question was, even though there's no EU law right to a zero rating, does the UK's exercise of its freedom to derogate bring with it the requirement to comply with principles of EU law? And the answer to that was yes. Turning the court up at the court's paragraphs 33 and 34, pages 391 and 392, paragraph 33 identifies that there the sixth directive has that phrase, a derogation maintained in accordance with community law, the letter H on 391. And then reading on, although the addition relating to being in accordance with community law was made only in 1992, such a requirement, which forms an integral part of the proper functioning of the uniform interpretation of the common system of VAT, applies to the whole of the period of erroneous taxation. And as the court has had occasion to point out, the maintenance of the exemptions or of reduced rates of VAT lower than the minimum rate laid down by the sixth directive is permissible only insofar as it complies with, inter alia, the principle of fiscal neutrality. And then 34, they draw those threads together to say that that principle of fiscal neutrality is one of the relevant principles when one is construing the zero rating pursuant to the derogation. There remained some debate as to whether that was always true, or at least always true in relation to the UK, and that was addressed in a case called Sub 1 in the Court of Appeal by Lord Justice McComb. Lord Justice Briggs, as he then was, I think, simply agreeing, and that is at pages 406. I'm afraid, well, I suspect that's a wrong reference. It is page 906. Sub 1 was the case I touched on briefly this morning. It was about food products. There were different forms of sandwich, toasted sandwiches, and included another product known as a meatball marinara. There was a debate as to where they fitted in for that purposes into the hot food, cold food debate. One wouldn't think it needed to trouble all the way to the Court of Appeal, but it did. But the issues in the case were significant from an EU law point of view, because the court has to decide how the principle of fiscal neutrality would apply in the context of a debate about the scope of zero rating. Picking it up at paragraph 57 in Lord Justice McComb's judgment, page 906, he identifies there was a second point of law taken, namely that the EU principle of fiscal neutrality cannot have the effect of overriding the UK's socio-political decision to exclude certain hot takeaway food from the zero rate exemption. So the Crown was saying you can't rely on fiscal neutrality to override the choice that the UK made. And the court concludes that it's not that simple. So picking it up at paragraph 60 at the foot of that page on this second point, the short answer is that of the learned judge, as Mr. Justice Arnold, below, which he then sets out, and it's paragraph 80 in the passage cited from below on page 907, I accept counsel for HMRC's submissions to the extent that the starting point that it is for the UK to determine the boundary between zero-rated supplies and standard-rated supplies. I also accept that the Court of Justice judgment in Rank and Isle of Wight demonstrate the principle of fiscal neutrality cannot be relied upon as depriving the UK of its discretion in this respect. It does not follow that the UK can draw the line in such a way as to discriminate between objectively similar supplies. On the contrary, Article 110 is explicit that exemptions must be in accordance with community law. And he refers to Commission in France and Marks and Spencer, make it clear that the maintenance of the exemption is only permissible insofar as it complies with the principle of fiscal neutrality. As in Ideal Tourism and the Commission of France, the UK can distinguish between supplies which are different from the point of view of the consumer, but as in Rank, it cannot distinguish between supplies which are the same from the point of view of the consumer. And consistent with Rank, that should be the same or similar. So the effect of that is that when choosing what to zero rate, which is a matter of discretion for the member state can treat different supplies differently. It cannot, consistent with the principle, treat the same or similar supplies differently. Does that then mean that necessarily, if you're required to treat same or similar supplies in the same way, that can lead you into a world in which you've extended the scope of the zero rating? Because that would run up against the requirement to give it a strict interpretation in line with a standstill. So how do those principles fit together? And that's also answered by my Lord's judgment in the sub 1 case, where by reference to the decision in Deutsche Bank, he says this, page 908, paragraph 64, where he cited from Deutsche Bank about not extending the scope of a zero rating. He says this: I accept Miss Whipple, who was appearing for the taxpayer, I accept Miss Whipple's submission that the case was concerned with a black letter line setting the boundaries of an exemption to be found in the directive itself. The exemption had to be construed strictly and the fiscal neutrality principles could not flex those boundaries. Here we are not concerned with such boundaries, we are concerned with a differentiation in treatment between traders supplying similar goods within the same national exemption category. So what the court there said is you can't rely on fiscal neutrality, even in the case of a derogation, to expand the scope of an exemption or a zero rating, but you are required to give it effect if you can identify that there is a differentiation in treatment between like supplies that fall within the same category. So when one is applying the principle of interpretation that is fiscal neutrality, it has to be concurrent with the strict interpretation and the purposive one. You can use it to ensure that goods within the same category receive the same treatment, but you can't rely on it to confer an exemption or a zero rating on a different category. Logically, that then leads to the third of my three questions, which is, if we're right on issue 1, without considering fiscal neutrality, then I don't need it. But if I'm wrong on issue 1, how can fiscal neutrality help? And that was a question asked of me in the Court of Appeal. I gave my answer to Lady Justice Simler. She records part of my answer, which is at paragraph 78, key documents, page 90, where I indicated that we were not likely to succeed on issue 2 if we'd lost on issue 1, because the digital editions were not of the same genus as the print editions. because in that world it would be unlikely that I would be able to demonstrate that there was a similarity of supply that would ground the application of fiscal neutrality. Equally, if we're wrong on issue 1, because the UK legislation is limited only to goods, then relying on fiscal neutrality may well be said against me to amount to an extension of the zero rating, which the fiscal neutrality principle does not permit. But equally, this court might decide that one needs to determine the scope of zero rating initially without regard to always speaking, and decide that the language is not limited to goods. Then consider always speaking and decide that newspaper does extend to these digital editions, but then decide for some other reason, which doesn't involve an extension of the zero rating, that one or more of these digital editions cannot benefit from that zero rating treatment. So you might conclude, I'm not inviting you to do so, but you might conclude that the e-reader gets home because it's a facsimile copy of print. You might say the same of tablet. The tablet is in effect the print edition. But you might say, well, reading the Times website is different. And at that stage, we would say, well, if that's the reason we've lost in whole or in part on issue 1, without regard to fiscal neutrality, we are entitled to pray and aid fiscal neutrality on issue 2 on the basis that the editions are similar to print, indeed fundamentally the same as the first tier said, and rely on fiscal neutrality as a principal interpretation to ensure that zero rating applies in those circumstances. But to reiterate, this is a problem I've created for myself by having fiscal neutrality in issue 2 and not addressing it as part of issue 1, when logically it's just a principle of interpretation and it ought to be factored in at issue 1.
It's all very elaborate, the arguments you're putting forward, but are you allowed, or do you say, accept that you're not allowed to make a simple argument, or relatively simple, that to treat electronic publications different from the print versions would be contrary to the principle of fiscal neutrality because it would be giving a distortion, competitive distortion in favour of print for what is a more or less identical product, and that's a reason to interpret the exemption as applying to both.
Well, I do say that. I'm dealing with the logical consequence of what may now appear to be a tactical error of separating these things out as separate issues.
Well, you're allowed to make that point on the interpretation issue if it's a good point.
And it is a point we make that they are fundamentally the same, designed to serve the same purpose. They should get the same treatment.
What I find much harder is your attempt to get back in if you don't get in on the first point. You seem to be going to all sorts of contortions to make that it's possibility.
I have to answer the question that was asked of me below and here. Is there anything left in issue 2 if I'm wrong on issue 1? And my answer is it depends why I'm wrong on issue 1.
Yeah.
And it also depends whether I'm right as regards some of the editions and wrong as regards some, and then maybe issue 2 has relevance. If I'm right on issue 1 before we look at that kind of contortion, then these submissions don't matter. Now, last heading was if fiscal neutrality otherwise applied, are there any other reasons why it shouldn't? The Court of Appeal decided this point against me on the basis that in order to give effect to fiscal neutrality, you had to find completing suppliers. And that was the Court of Appeal at paragraph 79, key document, page 90. That, we say, is not right. The court there is misreading Marks and Spencer's. What you've got to find is comparable supplies. They don't have to be made by separate suppliers. Equally, if insofar as it matters, there was evidence here that the first tier recorded and made findings of fact about that digital sales cannibalised print sales. Digital sales went up, print sales went down. And that's the first tier at paragraphs 118 and 121, key documents 139 to 140. So that reason given by the Court of Appeal, we say with respect, is not a good one. The commissioners in their written case also identify some other objections. Perhaps I'll come back to these in reply, but we've answered them in effect in our written case, and we say they don't amount to reasons not to apply fiscal neutrality if it otherwise operates. And I'll deal with those in reply if my own friend makes headway there. So that would take me to the last of my 5 headings. Where did the Court of Appeal go wrong? I can deal with this very quickly. It may be helpful to have to hand the Court of Appeal judgment. It's in key documents, page 66. We quibble, not for the sake of quibbling, because it does have some resonance later on. The First Tier Tribunal had characterised what we're seeking 0 rating for as digital editions. And the Court of Appeal adopts the term the digital news services, which we think rather begs the question. So we do object to that. But more significantly, the Court of Appeal places reliance on the debate about reduced rates in Article 98. That's in paragraphs 16 through to 20. Pages 69 through to 70. And then in paragraph 23, Her Ladyship says, I see the force of Mr. Fleming's submission that the legislative history provides important context. It's page 71. Well, the legislative history in Europe, as regards reduced rates, does not supply context, important or otherwise, for the UK statutory provisions we have to interpret. So with respect to my lady, we say that is just wrong. She then sets out the domestic framework. We have no difficulty with that. And she summarises the judgments below. We have no difficulty with any of that. So picking it up at paragraph 54, page 82, she has a heading, discussion and analysis. She sets out from 54 through to 57 principles of statutory interpretation. We have no quibble with any of that.
So paragraph 54, you're content with that explanation of how English law principles interact with EU principles?
Yes.
And I think paragraph 64, she goes into a bit more detail about which principles are relevant.
Yes, I was going to stop at 58.
Okay.
So 54 to 57 sets the ground we have no objection to. 58, she identifies the underlying social policy and then deals with always speaking. So we had no difficulty with 58 through to 62. And then 63, she makes the point about a concurrent application of strict interpretation and always speaking. And could add to that and fiscal neutrality. The exercise is a single exercise, 4 lines down in 63. We say yes to that. But then in 64, she draws the threads together. 5 lines down in 64, she says the EU principle of strict construction, the fact that that 0 rating is to be construed restrictively. We don't accept restrictively. That is to misread my lord in SAE education. Uh, 65 is fine. 66, we are content with, apart from the 4th sentence, which is about 9 lines down, that begins in the middle of that paragraph. Indeed, page 86, indeed, there is nothing in the wording of section 30 to suggest that Group 3 is not capable of being limited to tangible or physical items if that is what the drafter intended. We object to that because there's nothing in the wording of section 30 to suggest that group 3 is so limited. So we don't accept that of 66. 67, she makes the point that digital editions weren't around in 1972, and that's true. But then the question is, do they fall in the language that Parliament has used? And then 68 is her conclusion. She says the words used by Parliament lead to the inference that the clear legislative intent was to include tangible or physical items only. And then she gives her reasons. We don't accept 69, and that is set out by way of a critique in our written case, which I won't repeat. But then, moving on and not accepting 69, para 70, her second reason, consistent with the fact the provision in question is a zero rating provision that derogates from the general rule. And then she ends 70 by saying, and the circumstances of the enactment of Group 3 indicate a narrow or circumscribed parliamentary intention and not a broad permissive one. We know nothing of the circumstances of the enactment of Group 3 that would lead to that conclusion. The Ladyship is finding some narrow or circumscribed parliamentary intention, and she reiterates that in 71. Thirdly, one can't detect a clear purpose which can only be fulfilled if the newspaper is interpreted in the way contended for. We disagree with that. We say that's not right. And then she says, although the digital news services may well serve the same social policy purpose as newsprint, well, they do, the statutory language adopted by Parliament displays a narrower, more circumscribed purpose than that more general underlying social policy. She doesn't identify what that more narrow, circumscribed policy is, nor do we say there is one. And then in 72, her Ladyship concludes that print and digital editions are in effect not of the same genus because one is physical and tangible and the other is an intangible service. It's true that one is physical and one is intangible, but that does not mean they are not the same genus. There was no requirement on the face of the statute in 1972, nor in the purpose that the first here has identified, as to the medium by which the content of a newspaper was delivered. So we disagree with 72. And then her conclusions continue really following logically on in 73 and 74 as to how she thinks the upper tribunal fell into error. And we say once one corrects my lady's approach, then the upper tribunal did not fall into error. And then she deals with fiscal neutrality, and just so you can see what I mentioned a moment ago, she records in 78, page 90, because I'd accepted that if I'd lost the same genus of fact argument, it would be very difficult for me to succeed on fiscal neutrality. And that was, I'm afraid, part of my answer to her, but not all of it. And she then goes on to say, well, in effect, if you're wrong on issue 1, you can't be right on issue 2. And then the further reason she gives in paragraph 80, or paragraph 79 is it has to be different suppliers, which we say is wrong. It's a misreading of Rank and Marks and Spencer's. And then paragraph 80 is you have to, in effect, show competition between suppliers in order to engage the requirement for comparable treatment. And we say, no, that's to misread, again, Rank and Marks and Spencer's. But the heart of the case against us, as set out in the Court of Appeal's decision, is the conclusion that because Parliament determined in 1972 to deal with print editions, it can only have intended to deal only with print editions, such that an application of 0 rating to a digital edition offends strict interpretation and/or the standstill, and cannot be saved by always speaking, because again Parliament must be taken by the words that it used to address only newspapers in print. And that thesis, accepted by the Court of Appeal and by the First Tier Tribunal, is, we say, wrong, but it's wrong for the reasons that are given in the upper tribunal, that one can't proceed from a reading of the UK statutory language to a conclusion that newspapers in digital form are excluded from the 0 rating.
Can one see the strict construction principle as a kind of aspect of fiscal neutrality, in the sense that the basic aim of the VAT regime is to harmonise tax and create a level competitive playing field, and exceptions to that should therefore be generally treated as limited because they detract from the basic purpose of the legislation? Or is there some other reason for treating the exemptions restrictively?
It is that reason, my Lord, that there is an expectation in a world where the system is purely harmonised, everything will be the same across the whole of the European Union. We're not yet in that world, or the UK wasn't even pre-Brexit, so therefore you had to adopt a strict but purposive reading of anything that derogated from that, because you were moving away from the general system, which was in principle not attractive.
So just extending that thought, could you say, well, okay, treating the exemption as applying to electronic as well as printed newspapers does extend the scope, does make the exemption wider, and in that sense it leads to a more harmonised world, but it creates its own local inconsistency in treating essentially equivalent products differently, which, as it were, offsets that wider consideration. Well, I haven't put it very well, but I'm trying to say that there may be two sides of the same general question.
Well, look, they are, but perhaps putting it that way really captures the nub of the debate between the parties, because my contention, your lordships have, is that one can read newspaper in a particular way, perfectly consistent with all the UK rules. I'm going to say you're required to do that. And my learned friend says, well, if you do that, you're contravening the guardrails set by European law, even in a world where the UK operates pursuant to a derogation. And my case is no, interpreting the meaning of the term, or giving meaning to the term by interpreting it, is not to extend it. And if I'm right about that, then I ought to get home, and if I'm wrong, I won't. Now, unless I can help the court further, those will be my submissions in opening.
Thank you very much.
roadmap for my submissions. In part one, I'll set out our position on the relevant statutory purpose in play. In part two, I'll make submissions on the always speaking doctrine, its application to this case. In part three, I'll cover the EU law constraints on the correct interpretation of the zero rating provision. And in part four, I'll deal with fiscal neutrality. So if I could turn then to part one and some general submissions on the statutory purpose in play. The schedules of the various acts which list zero-rated supplies are, of course, the way in which Parliament communicates by statute the identification of particular kinds of supplies to which Parliament has chosen to give a VAT-free status in pursuit of a social policy and for the benefit of the final consumer. There is, we say, no discernible statutory purpose to zero-rate all supplies or kinds of supplies that may meet the relevant social policy, but only those supplies particularly identified. In effect, there's a dual relevant statutory purpose in relation to zero rating: to zero rate in pursuit of the social policy for the benefit of the final consumer, in fact, purchasing the supply, but also to standard rate other supplies which may also meet the social policy, but to standard rate them nonetheless, ultimately for the benefit of the public, through the receipt of funds from taxation. And there are no doubt many supplies that are worthy of zero rating in the pursuit of a social policy for the benefit of the final consumer, but not all supplies are zero rated and not all worthy supplies are zero rated. And there's an evident discrimination by Parliament as between supplies. So to give your lordships a few examples in the food group, oranges and fruit generally are zero rated. Orange juice and all fruit juices, which are fruit in a different form, are standard rated. Chocolate-coated cakes are zero rated. Chocolate-coated biscuits are standard rated. Some of the decisions stretch back to the purchase tax, which itself charged tax on juice and chocolate biscuits. Some are decisions made in 1972 under the Finance Act in preparation for entering the EU. So, for example, under the purchase tax 1963, toothbrushes and toilet paper were not taxed. Soap was taxed. A decision was made in 72 not to zero rate any of these. And clearly these are basic essentials for hygiene and health that benefit the final consumer, but evidently Parliament was willing to forgo tax for certain supplies to benefit the consumers, but for others it was not willing to forgo the tax. The second purpose, receiving taxation for the general public good, won the day. It's not easy to understand why cake has always been free of VAT, but soap has always been taxed. But these are the political decisions made, presumably, for the purpose of receiving taxation for the public good. And the most recent zero rate is that from the 1st of Jan 2021, a post-Brexit zero rate. Women's sanitary products, including panty liners, are zero rated, but not those designed primarily for use as incontinence products, which are standard rated. That's the new zero rate. Parliament evidently considered that this was a good choice to make, but that a zero rating for incontinence products, however worthy or equally worthy, was an expense too far. And coming a little closer to home, if your lordships could turn up Authorities, page 50. This is the 1972 Act, the original schedule for zero rating, and it'll be seen at page 50 that there was a Group 6 news services. Item number 1, the supply to newspapers. Newspapers there is used to mean newspaper publishers. The supply to newspapers or to the public of information of a kind published in newspapers. Note, this item does not include the supply of photographs. Now, that group continued to exist until its repeal in 1989. It was a group considered by the CJEU when infraction proceedings were brought against the UK, in particular on the basis that some of the zero rates were not for the benefit of the final consumer. The EU Commission, which brought the infraction proceedings, made no complaint about Group 6 in relation to the provision of information of the kind published in newspapers to newspaper publishers, or when it was to the final consumer. What it objected to was the reference to the public, because the public might include information supplied to banks or insurance companies, and that was not regarded as for the benefit of the final consumer. And for your note, the CJEU agreed with the Commission, and the answer is given at Authorities page 291, paragraphs 26 to 29. Now, despite the ability to continue to provide the zero rate for news services under that group, and to meet the CJEU judgment simply by reducing the scope of that zero rate, Parliament repealed it. I don't know or seek to rely on the particular reasons for repealing that group. The point I'm making is that supplies of information to newspaper publishers or to the final consumer of a kind used in newspapers, so for example Reuters sending news information to publishers, or even a journalist sending an article, supplying an article, would of course meet the social policy identified by the FTT at paragraph 17, but was nonetheless brought into the standard rate. Now, the way that zero rating provisions discriminate generally is twofold. Sometimes there's a very general category, food and drink, with carve-outs for particular types of food and drink, which are then brought back into the standard rate. Other times, including in relation to our Group 3, the zero rating provision itself is more specific and thus excludes, by being specific, supplies that don't qualify within the meaning of the term or concept used. So we know in our group that the social policy pursued by Parliament for books and newspapers, etc., was the promotion of literacy, dissemination of knowledge, democratic accountability by having informed public debate. It's not clear that the first-tier tribunal thought that all those aspects had to be met by each of the items dealing with books and newspapers. It's likely that not all such items must meet every aspect of the social policy. It's hard to see how children's books promote political engagement or democratic accountability. Item 1, books capture many supplies that have nothing to do with promoting informed public debate, and capture books you look at, that is, books having pictorial information which won't help literacy. By zero rating books and booklets, Parliament provided VAT-free access to play scripts and to theatre programmes containing information about the performance, but chose not to zero rate tickets for admission to actually see the play. Most, though not all, theatre admissions are now exempt, but that's been the case only since 1996 under an EU exemption, and is now in Schedule 9, Group 13. In 1972, when Parliament was deciding what to zero rate, it evidently made a choice not to zero rate admission to such performances. But it can hardly be said that the play script is a clearer instance of disseminating knowledge than the performance itself. So we say there's no discernible purpose to zero rate all supplies that may meet the social policy that might be worthy of the zero rate. And there's a discernible purpose to zero rate only what is selected and no more. First, items 1 to 3 don't refer to supplies of reading matter or pictorial information or use similar general language. They pick out particular forms the identified supplies take. So books, booklets, brochures, pamphlets, leaflets. And in selecting the particular items, and by being specific, some supplies which meet the social policy do not fall within the group. So children's books are 0 rated, including painting books. Children's dictionary cards used for learning words, not being books or booklets or leaflets or pamphlets, are standard rated. And there's a decision to that effect. I can hand up the case, or I can give your lordships the reference. I don't think it's in dispute that dictionary cards have been found not to be within group item 1. And obviously dictionary cards are surely more useful for the promotion of literacy than children's painting books. Books and newspapers are 0 rated. Microfilm or microfiche containing miniaturized content of books and newspapers is not 0 rated. And such microfilm existed in 1972, and yet Parliament didn't add it as an item. Now, to meet a potential counter-argument that microfilm could come under the term books itself on the basis of an old decision, Barker and Wilson, in case my learned friend wants to deal with that and reply, I'll just take you to the case now, but I have to hand it up. Do you have Barker? Barker and Wilson related to the meaning of banker's books and whether microfiche, which was in the modern time used to record what had been recorded in bankers' books, whether that came within a statutory definition. My Lords, you'll see at the bottom of the first page is the relevant provision that was in play in that case. Bankers' books include ledgers, day books, cash books, account books, and all other books used in the ordinary business of the bank. And the question was whether the microfilm qualified under that definition. And the answer given at page 887, C to F, if I could just read from C. Checks are not included in the order which was made by the Justices. For myself, I would not like, without further argument, to include in this judgment any view as to whether checks come within the meaning of the word book as used in Section 9, the definition section of the Bankers' Books Evidence Act 79. But I have no doubt whatsoever that the definition section does include microfilm, if microfilm is used by a bank to record the payment of checks by photographing the name of the payee and other matters. So as far as I can see, and indeed it is a matter of common sense, microfilm is itself an entry which is maintained by the bank in respect of the customer's account. Therefore, if in this particular case the books which are held by the bank in respect of the defendant's accounts are really a microfilm process of the transactions which the customer has carried out at his bank, then microfilm itself is within the definition contained in Section 9. Although it would not be called in ordinary language a book, a banker's book in ordinary language would not be called a book. Book is a word which is used in many contexts, but I have no doubt at all that the actual microfilming of actual transactions and actual checks do come within the definition of bankers' books. So the court there considered that microfilm was not within the ordinary meaning of book, which must be right, and bankers' books themselves were not in the ordinary meaning of books. So nothing in that case suggests that microfilm would come within the 0 rating item of book. And the point I'm making is that Parliament, although these things existed, the same content in a different form on a different medium, microfilm rather than printed paper, Parliament didn't include it in Group 3. My learned friend also must accept my submission so far because he says rolling news aren't included in Item 2, Group 3 newspapers. And he says that such rolling news supplies don't even come into the new Item 7. You see that is in the Statements of Facts and Issues, Key Documents Bundle, page 2, paragraph 3. But we say there's nothing in the social policy identified by the first-tier tribunal which excludes them. Obviously, rolling news type supplies also disseminate knowledge and further literacy and improve democratic accountability by informing public debate and so on. And yet, even on my learned friend's case, those are out of the 0 rate. And what excludes them, on my learned friend's case, is the meaning of newspapers, a point I'll come on to, but it's not the social policy. He accepts that they meet the social policy in play. If we turn up my learned friend's written case, page 26 of Key Documents.
I have to say, I'm struggling a bit with what this submission actually, where it's taking us, because as I understood Mr. Peacock, he wouldn't dispute that the social policy is wide enough to include various other possible items, but isn't his important submission that it's got to also satisfy the word newspapers and fall within the relevant policy. So I'm not entirely sure what you so far said, why that counteracts what Mr. Peacock's submission is.
My Lord, yes. The reason I'm doing this quite carefully and perhaps you'll be over-labouring it is because when we come to look at the always speaking doctrine, in my submission, what in fact happens is the courts apply the always speaking doctrine to apply an updated construction where the statutory purpose allows them to. And it's always with an appeal to the statutory purpose. So to take Quentinville, the question was, did a statute that protected embryos created by fertilization also apply to protect embryos created by CNR? And the obvious answer was, well, of course we must update it and take into account this new technique, CNR, because it's unthinkable that Parliament could have a statutory purpose to protect one type of embryo and not the other. And I'll come on to cases like Victor Chandler as well, which my learned friend relies on, where it said, so Parliament wanted to protect the revenue and protect onshore bookmakers from competition offshore by preventing advertisements being issued here. What possible reason could Parliament have not to include a very modern type of advertisement that is issued electronically? So it's always an appeal to purpose that gets someone home on the always speaking doctrine. And in my submission, therefore, it's very important that we identify carefully what is the statutory purpose in play. And my learned friend and the upper tribunal appeal to the fact that these digital news services meet the social policy as though that's an answer to the case. It said, well, they disseminate knowledge and further literacy and so on just as much as their printed cousins. Why would Parliament want to exclude one and not the other? What I'm trying to do through my examples is show instances where Parliament has discriminated in this way. So the oldest example is, we'll tax oranges, but not orange juice. Supply in a different form, a different medium, if you like. But I'm coming on to other examples, which in my submission show that Parliament wants to put the statutory purpose in play, the discernible statutory purpose in play, is to zero rate what's selected. What was selected in this case is printed newspapers. When you ask, is it clear that Parliament would also want the modern newspaper, the electronically supplied newspaper, to be included? As one might ask, is it clear that Parliament, of course, wants to protect embryos created by CNR? The answer is not clear. So, perhaps I don't need to say more about rolling news, but I'll turn to examples which show that Parliament cares about medium. My Lord, does that sufficiently answer your question
Thank you.
for me to get back to the examples?
Yes, thank you very much.
Your point, as I understand it, is that Parliament can be very specific about what it puts into the zero rating policy and what it puts into the standard rating policy to raise revenue, and that you were discouraging us from generalising because you were saying look very carefully at the specific words, because boundaries are crossed very easily, and some things will find zero rated, other things in the same genus will find standard rated.
And not just at the particular words, but as I hope my next two examples show, particular medium sometimes matters. My learned friend's great answer is these supplies are identical or extremely similar other than the medium. And we say sometimes medium matters. So there's no discernible purpose, and it's this kind of purpose that my friend must rely on, no discernible purpose that when new innovations come along of the supplies that existed in 72, that Parliament rushes to take them out of the standard rate. And I have two examples of that. First, it's been open to the UK as a member state to apply a reduced rate to books that are supplied on any physical means of support since 2009. So if I could show you the EU reduced rate regime.
Could you just remind me of my note? Does this have a reference in your case, in your written case? The examples you're going to take us to, so that I can.
I don't think I particularly included these two examples in our written case.
That's fine. Thank you.
The setting out of the EU regime and where it allows derogations, and which of those derogations it controls and which it leaves to the member state are set out in my written case. Just trying to think if it's easier if I take it from there.
Well, I don't want to take you out of your course. I just wanted to see if there was a reference that I could make a note to. But I understand your submission about books on any physical support, and I think you're about to give us a reference to that.
Yes. So if you turn up authorities. We've got several versions of the 6th directive, and I'll just show you how it evolved. Right. So some of the index mislabels the period for the directive. So if you turn to page 21, authorities.
Page?
21.
21.
That's Annex 3, and point 6 is the EU permitting. Remember, the standard position is VAT on everything at the standard rate. Across Europe, the standard rate can't be lower than 15%. And then there are various exceptions. One form of exception is the EU reduced rate, where the EU says in this Annex 3 list, for these supplies we've identified, you member states can apply a reduced rate as long as it's not below 5%. And initially, we can see in 6 it had the supply, including on loan by libraries, of books including brochures, leaflets, similar printed matter, children's picture drawing or colouring books, music printed, and so on. That was the original position. Then in 1992, a change was made, and if you just compare, is it what's in here? Yes, you have to compare page 9 to page 21 to see the change. So the EU reduced rate went from books, brochures, children's books, newspapers, and so on, pre-92, to a change in 92, which took the form on page 9. Supply, including on loan by libraries, on books, on all physical means of support, ... Now, my learned friend was making submissions earlier today as though physical means of support means books on CD-ROM and so on. It means books on any physical means of support, i.e. paper, CD-ROM, DVD, USB stick. What the EU had done was move from only printed to all physical means of support, whether that is paper, CD-ROM, USB stick, and so on. And that's the reduced rate of 5%. And it's been open to the UK. Remember, zero rates can't be expanded beyond their 75 or 1991 borders because of the standstill prohibition. But these EU reduced rates are there and can be picked up at any time. The EU is simply saying to the member states, for these supplies we've selected, you can always have 5% reduced rate. And it's been open then to the UK since 2009 to apply a reduced rate to books that are supplied on, for example, CD-ROM, CD, USB stick. The effect of that would be that it could apply just the 5% rather than the standard 20% VAT. Parliament was no doubt aware from 2009 till today that HMRC didn't consider these kinds of CD books were zero rated within Group 3. Tax has been charged on them at 20% since they emerged as supplies, charged at the standard rate. And yet Parliament didn't act at any point to apply a reduced rate to books on CD-ROM, USB stick, and so on. And obviously Parliament must have known that HMRC is charging 20% on these supplies, not charging, but asking supplies to account at 20%. The leading authority, such as they are, there aren't many authorities in this area, but on what an ordinary book is, was that it was an object of printed pages. This was the case of colour offset. For your note, I don't think we'd need to turn it up, but it's page 503 of the authorities bundle. The question was whether blank diaries were books for zero rating. And Mr. Justice May said books were objects whose necessary minimum characteristics are that they have a significant number of leaves, now usually of paper, held together front and back by covers, usually more substantial than the leaves, which are to be read or looked at. And on the basis of that definition, the diaries, the empty diaries, were not regarded as books for zero rating purposes because they had nothing to read or look at. They were blank. They were meant to be written in. So my blue, as Mr. Justice May says, my blue council's notebook is not a book, according to his ordinary meaning. The point I'm making is that the case law had taken the position that books are paper books, paper objects made of...
Well, it said that way here, but was there a case on whether e-books were books, or or has there been? I mean,
No.
This is all in the context where the only items in play were physical items. The question was whether if it's got no content, it's a book or not.
No, and I'm not relying, quite rightly, on colour offset to say, and therefore CD-ROM books couldn't be books. What I'm relying on is the state of the authorities was books are objects made of paper. HMRC, since these supplies emerged, has been asking suppliers to account for them on 20% VAT. It's put it in its guidance and so on. It must have been clear to Parliament for all these years that the UK is not treating CD-ROM books and books on USB as though they are zero rated. And yet, in all these years, it hasn't once thought to reduce rate them. It couldn't zero rate them if they hadn't already been zero rated by 91. But nothing was stopping it reduce rating them. So it's been benefiting the public by getting 20% VAT on these supplies, opting, and it must have been a choice, opting not to receive 5%.
Were these illustrations used below?
No.
Might it be thought a little bit unsatisfactory that you're inviting us to draw an inference from these particular examples when they haven't been explored in any tribunal below?
But I'm not. I'm trying to think if it is in any way unfair. It's simply. We've never accepted below, perhaps this is the right way to answer it, we've never accepted that there's been a social policy to zero rate everything that meets the social policy. And that's in our written case, that it's a necessary condition, it's not a sufficient condition. These are two even better examples which show that Parliament can even care about the particular medium. So it's made such decisions where it's allowed CD books on book content on CD-ROMs and so on to remain at the standard rate.
It's not a very strong argument, is it, to say that because Parliament hasn't amended legislation, that is relevant to what it means? I mean, you might just as well say, if you were adopting that argument, that Parliament didn't amend the exemption on newspapers at a time when HMRC was claiming that electronic copies were not newspapers, and that shows that your interpretation is right. But I mean, that's the whole question, is whether your interpretation is right. And at the time when Parliament hadn't made any change.
My Lord, I think I do have an answer to that last point and why it's not a parallel situation. In the CD books on CD-ROM position, it's been since 2009 that there's been a power to reduce rate these. It's been clear since 2009, if you look at any of HMRC's guidance, that these are not treated as zero rated, yet Parliament hasn't acted. So that's lots of years where Parliament hasn't taken any action. In the parallel situation that's been put to me, which is not, I say, a parallel, there was no case law supporting the idea that electronically supplied newspapers might be newspapers. The first decision to say that such things could be newspapers was the upper tribunal in this case. By the time of the upper tribunal decision in this case, the new directive, the 2018 directive from the EU, had come into force. So it was too late for Parliament, and I think this is what my Lord Legate is putting to me, it was too late for Parliament to act to correct any past, to make even clearer that newspapers meant printed newspapers. It couldn't do that for the past. And going forward, the new directive would come into play. And we'll bring copies of the explanatory note to the new 2020 item 7 tomorrow, because whether your Lordship thinks it's relevant or not, it's a fact that the explanatory note makes clear that the UK thought it was acting under a power given to it under the 2018 directive. So I hope that answers the point that's being put to me, in the sense that there was no reason for Parliament to ever take parliamentary time up to make even clearer that when a statute says newspaper, it must mean printed newspaper. Nothing to suggest the alternative until the upper tribunal decision in here. By then it was too late, and the whole thing had changed anyway because of the new EU directive. And another example, the other example is in the new 1994 Value Added Tax Act. So can we start by looking at the 2018 directive? That's page 22. My Lords, if you look at page 22, recital 3, starting halfway through recital, starting for the same reasons. For the same reasons, it's appropriate to allow those member states that, in accordance with the union law, currently apply VAT rates lower than the minimum laid down in 99. Pausing there, lower than the minimum laid in 99 is something called a super reduced rate. So the EU says reduced rates can be no lower than 5%. There are these things called super reduced rates, which are very like zero rates. They're something that is tolerated but not expressly decided on by the EU. And note, the minimum currently apply super reduced rates lower than the minimum laid down in 99, or that grant exemptions with deductibility of the VAT paid at the preceding stage to certain books, newspapers, and so on, to apply the same VAT treatment to books, newspapers supplied electronically. When you see in EU legislation exemptions with deductibility, those are zero rates. My learned friend sought to suggest that this directive deals with a harmonised area. There are no harmonised zero rates. Zero rates and super reduced rates are those tolerated under originally Article 28(2)A of the 6th Directive, and now transposed into the Principal VAT Directive 2006, Article 110. It's in that, if you like, non-harmonised area that these exist. But this directive thought it was giving power to those who were applying zero rates to books and so on physical means of support, which in EU speak means paper or CD-ROM and so on, to extend that to electronic supplies. And we see that, that's the recital. If you turn over and actually look at the amendments made, over the page we see Article 99 and the amendments that this 2018 directive brought in. By way of derogation from paragraphs 1 and 2 of this article, in addition to the rates referred to in Article 98, Member States which on 1st of January 2017 applied in accordance with Union law reduced rates lower than the minimum laid down in this article or granted exemptions with deductibility, i.e. zero rates, to the supply of certain goods referred to in point 6 Annex 3 may also apply the same VAT treatment where the supply is supplied electronically. And you see that Annex 3, which I took you to earlier, has been amended to include not just books, newspapers, periodicals on physical means of support, but also those supplied electronically. It includes ... maps. And then at the end, other than publications wholly or predominantly devoted to advertising, and other than publications wholly or predominantly consisting of video content or audible music. And that's what the UK thought it was, well, on my submission, that's what empowered the UK to make the 22 changes that it made. And that's why you see the reference to advertising and video and so on. The reason I go to this specifically is just to show you that the 2018 directive permitted the UK and other member states that had by 2017 applied zero rates to these things. So not all of them, because after all, the EU's primary goal is to get rid of all these derogations. It's to make everything taxable at a standard rate. But for those who had by 2017 applied the zero rate to maps, books, and so on, in order to avoid offending fiscal neutrality, those states that applied a certain treatment to printed books, paper books, and so on, could apply that rate to electronically supplied services. But look at what the UK in fact tried to do with this new power. If you look at page 70, new item 7. Publications listed in items 1 to 3 when supplied electronically but excluding ... are 0 rated. So the UK decided in 2018 that it would use this new power to 0 rate electronically supplied books, newspapers, children's books, but not to 0 rate electronically supplied maps. It had the power to 0 rate electronically supplied maps. It decided not to go that far. And I don't know what the specific social policy is behind 0 rating printed maps. Whatever it is, it's hardly going to be different when it comes to electronically supplied maps. So one can't take as a starting point that whenever Parliament, whatever fits the social policy or fits it equally, in an equal way to things that have been previously 0 rated, Parliament will rush to 0 rate them. There is nothing odd, illogical, irrational about Parliament saying, given its wish to also have taxation, we'll 0 rate printed newspapers, we'll give you VAT-free access to printed newspapers, but for anything else, you can pay the VAT. Or perhaps its position is, we'll give you VAT-free access to printed books and newspapers and so on, but we won't give you VAT-free access when a device is needed. CD-ROMs need a device, electronically supplied services need a device, microfiche film needs a microfiche reader to be read. So essentially, when you get those, when you get microfiche or electronically supplied services or CD-ROMs, you don't really have access to the information on them without a device. I'm only speculating, and I could fully accept that. We don't know why Parliament decided to 0 rate in some cases and to benefit from the tax in others. What I'm trying to make clear is this is not like the embryo case where everything falls one way and there's nothing on the other side of the scales. It's perfectly rational for Parliament to say, well, you can have the minimum necessary for the social policy. You can get your printed newspapers VAT-free. But for anything else, we'll take it into the standard EU position that there will be tax on these things. Perhaps it was concerned that there would be a call for the devices that these things are read on to also be tax-free, which is what happened in the Brazil case that my learned friend put in the authorities bundle. We don't know the reason, but it's clear that it has made these choices, and it can't be said that these choices are irrational or incomprehensible or purpose points only one way, as it's been said in Quentinville and Victor Chandler and so on. And I hope I'll show when we get onto those kinds of cases that there isn't that parallel that my learned friend can rely on.
In a sense, you're saying that the granularity of the decision-making by HMRC and through HMRC by Parliament means that one can't just look at a social policy and see if it fits. And similarly, you're saying you've got to be very careful about using a particular genus, because it's quite possible within that genus, Parliament may 0 rate some things and not others. Is that really what this point is being directed
Yes, I don't accept that printed newspapers and electronically supplied services are in the same genus, and I'll make that submission when I come to Quentinville.
Yes, but even if they were...
Yes, it can't be assumed that it had anything that fulfills the social policy should be zero-rated. That's common ground. But it also can't be assumed that anything that fulfills the same social policy in the same way, in the sense that it's the same information that one gets on a CD-ROM book.
And this is your point about medium, yes?
Yes.
Yes.
Or electronically supplied maps versus maps. There isn't a policy to zero-rate all future forms as well, which is what the always speaking doctrine relies on, isn't it? That Parliament wants and expects that its legislation will be around for many years or decades, and that it must take into account future developments, either in social attitudes or in innovations and so on. That's the general reason for applying the always speaking doctrine. But here, one simply can't assume that Parliament would want to zero-rate anything that does the same job as a printed newspaper, because when things that do the same job came onto the market, Parliament either didn't act at all to reduce rate the CD-ROM books, or, this is a very recent 2020 change. Surely Parliament had a good think about which of these supplied electronically wanted to zero rate. Had no EU restrictions. There was no fear that it was overstepping the mark in any way. It looked at the list and said, we'll apply it to books and newspapers, but not maps. So my learned friend can't say, well, this is something you'll see in his written case repeatedly. Possible reason could Parliament have to discriminate on the basis of medium? It's taxation. Every time it doesn't zero rate, for the benefit of the final consumer, it benefits for the public. One can't say it's not meeting the social policy because it hasn't zero-rated all maps. It's giving access, VAT-free access to maps. It's just not giving VAT-free access to all maps, no matter the medium. And I'm making these points in the field of always speaking, but of course, even if you're completely against me on that, my submission, just to make clear, is that even if my learned friend gets through the always speaking doctrine, you can't get over the non-extension of scope restriction from the EU.
You're going to come back to that.
Of course, that's the second part of my submissions, and that's key, because if I fail on always speaking, that's my next line of defence.
And I take your point that Parliament can draw arbitrary lines if it wants to, because there's two competing policies, but still, when you're construing what the words mean, it's surely relevant that whether a distinction would be a rational one or not. Parliament is not going to, as it were, zero-rate maps with a red cover and standard-rate maps with a green cover. If the distinction is a seemingly arbitrary one, that's a reason for interpreting the word as encompassing both species, if you like.
I agree that it would be very odd if it was red maps and green maps. What it is, though, is printed maps and electronically supplied maps, and that's not such an odd distinction to make, because there are printed maps in the world. It is benefiting the final consumer by having VAT-free access to maps, but it's not giving VAT-free access to maps no matter the medium. It's also, and I have to admit this is speculation, but I think I'm being invited to explain how is this not arbitrary? So I'm trying to offer potential explanations by distinguishing between, when I buy a printed map or a newspaper, I'm buying everything I need. I'm getting the supply that Parliament wants to give me. When I buy electronically supplied services or CD-ROM USB stick supplies, I don't have anything yet until I get a device or a screen, internet access, chargers, and so on. So that there is a clear difference where Parliament might have thought, well, we'll only zero-rate the minimum, and we'll choose things that are self-standing.
Well, that may be thought to be true, but it may also be thought to be unlikely that persons are going to buy their device simply to get access to the newspaper. I mean, one's going to use whatever devices you have, and if people are looking at their newspapers on devices, they're not going to buy a paper copy. They're not going to buy a device to get the newspaper. Wouldn't have thought, in the general case anyway.
My Lord, that's true for today. It's not true for the microfiche first example I gave, where microfiche could only be read on microfiche readers. Today, though, I don't think it's in dispute that Parliament has indeed zero-rated only printed maps and not taken the opportunity to zero-rate electronically supplied services. I mean, it's simply done it. And I don't really have to explain or suggest reasons beyond what I've suggested, because we know it's done it, so it can't be said against me, there can't be any possible reason to discriminate on medium. Well, it's done it, and recently. So there is the basis for discriminate. One can't assume that it doesn't discriminate on the basis of medium. And sorry, the other answer, and I will come on to it, but so that it doesn't fester in any way, the other obvious answer is, of course, Parliament, and this is common ground, would not want to extend the scope of the provision. So it's only through the always speaking doctrine that my learned friend can try to get home. If Parliament tried to legislate when electronically supplied newspapers came on the market and tried to say the zero rate now includes newspapers and digital news services, there's no doubt it would have been facing infraction proceedings from the EU. The EU, as is clear from the directive, considers that it empowered member states to do what the UK did in 2020 under the 2018 directive and not before. And my learned friend can say it doesn't matter what the EU legislature thinks, but that's what it thought. The EU Commission thought that nobody could do it before the 2018 directive, and that was in evidence below.
I don't see how you can get that from the face of the directive, because suppose a country had a zero rating for something that said printed books, or books printed on paper, or books on physical means of support, which they might have done. Then the 2018 directive would have then enabled them to extend that to electronic supplies, which they wouldn't otherwise have done. In our case, the whole question is, what had the UK already done? If it was limited previously to books means printed versions, then it needed the 2018 directive to extend it. If books already included e-books, let's say, then it didn't.
Yes, and that's why I don't make that a major part of my submissions, but just in order to correct that what I understood my learned friend to be saying, the EU Commission was clear, and I'll find the paragraphs in the judgments below. The EU Commission thought no member state could have been in a position of zero rating electronically supplied services, because the standstill came down in 91, and it's common ground these things didn't exist in 91. EU Parliament, the EU legislature, on the basis of this directive, apparently thought that it was giving permission. But that doesn't, as my Lord Legate has set out, it doesn't exclude the possibility that some member state had, through interpretation, got there before it. The UK Parliament thought that when making the 2020 changes, it was exercising a power given to it under this directive. I'm not saying that's decisive, I'm just correcting my learned friend's position and showing that I'm in good company, in the sense that the EU Commission, UK Parliament 2020, EU Parliament, EU legislature seems to agree with the submissions I've made so far. And that's not hard to see, as I'll explain when I come on to the extension of scope question, because the standstill comes down in 91. The content of your national zero rate is frozen in 91. And so, I mean, I'll explain this further, but the idea is that these things that didn't even exist in 91 and are very different from what existed in 91 won't be in.
In the case of the UK, it was frozen in 1975 because
Yes.
they couldn't thereafter
Yes.
innovate. So in 1991, their position is backdated to 1975.
Yes, yes.
Yes.
Absolutely. 1991 was a kindness done to, I think it was Austria, Finland and Sweden, which were about to come in 95. Would have been a bit unfair on them to say,
Yes.
you can keep the zero rates that were in 75 when perhaps it hadn't even heard of the EU. As time has gone on, the EU has become less tolerant. So by 81, Greece, 86, Spain, Portugal come in. They're stuck with the 75 date. 2004, a whole raft of member states come in. They get the 1991 date. So, I mean, there's a couple of particular provisions made for Malta and Cyprus. I think food.
But when we're addressing the UK position, we're focusing on 1975.
Yes.
Yes.
And that's common ground. So it had to be the scope in 75, nothing to suggest that it changed from 75 to 91. So we say, in effect, not only is meeting the social policy a necessary condition but not sufficient, which is common ground, but I say that once you've got over the necessary condition, once you've met the threshold of, yes, this is a supply that meets the social policy, you can put social policy away. It's not going to help you in identifying whether the always speaking doctrine applies to this situation, because one can't discern a social a statutory purpose to zero rate as much as possible that comes within the social policy, or as much as possible that is similar to newspapers. My Lord, I think on that basis I can turn to part 2 and the always speaking doctrine, unless there's anything on the sort of general statutory purpose submissions that your Lords have any questions on.
Yeah.
So part 2, the particular aspect of the always speaking doctrine that's in play is that which holds that a new innovation, not in the contemplation of the legislature, may nonetheless come within a term selected by the legislature. To be clear, we don't oppose the application of the always speaking doctrine in principle. So, although not framed under the doctrine of always speaking, when we've argued cases on new innovations, we haven't said, it's a new innovation, end of story. To give you an example, to give your Lordships an example, vegetable smoothies or fruit smoothies are a new innovation. They didn't exist. They weren't readily supplied in 1972. You couldn't pick up a fruit smoothie from a cafe. When these came onto the market, they are a new innovation, not in the contemplation of Parliament. But nonetheless, one can look at the characteristics of these new products and say, are these food and drink, therefore standard rated, or are they a beverage or a juice and therefore standard rated? Sorry, so food and drink would be zero rated, a beverage or a fruit juice is standard rated. And one can ask that question and answer it on the basis of the characteristics of the product. But HMRC's position is that one looks at the characteristics that emerge from the products that did exist in 1975 and asks, do these new products meet those characteristics?
And what is the status of a fruit smoothie as a matter of interest?
So a fruit smoothie, I'm afraid,
It's standard rated.
it is standard rated. It's a beverage close to fruit juice and not drink. It comes within the exception to the zero rating. And another example might be genetically modified tomatoes. I assume these didn't exist in 1972. but they meet the characteristics of food and tomatoes that did exist in 1972. And my lords, you'll know the point I'm making. Electronically supplied newspaper. I'm going to be criticised for using the term newspaper, so I have to be careful. Digital news services are new innovations, and one can ask, are they newspapers? But when answering that question, one has to bear in mind the genus of fact, kind and dimension, key characteristics of the newspapers that existed in 1975. And in 1975, newspapers were not synonymous with their journalistic curated periodical content. They were a physical object made of folded sheets of paper containing news, or, depending on the newspaper, more adverts, more news articles and so on. But when one asks the genus of fact question, or kind and dimension question, it's very odd, we say, to simply ignore the fact that one was a physical object and the other isn't.
What would you say if a new material had been devised other than paper, but a physical material, but a new form of technology perhaps that produced something that looked like a newspaper but wasn't made? Is it essential that it's printed on paper, or can it be in some other physical form?
I'd have to take instructions, but can I answer it this way?
You may say it, so you don't have to give an answer to that.
Well, can I answer it this way? That's certainly a harder case, because when one asks, is it the same genus of fact, does it meet the key characteristics, it may seem, although I'll be corrected by those behind me, that it's a bit of a quibble to argue about whether it's paper that's folded, an object made of folded paper, or folded some kind of new material that hasn't been invented yet. But that's a hard case. On my submission, this is an easy case. It's not even an object. And anyone trying to give a meaning to newspaper in 1975, 1991, but 1975, who failed to point out that it was a physical object, would be accused of not speaking English or understanding English properly. If I was in this room and somebody was trying to, in 1975, and somebody was trying to guide me to newspapers and use my learned friend's definition, and said it's curated journalistic text, I'd have to go through all those books on the shelves before I realised that those aren't newspapers, and I'd be very upset that he hadn't guided me to the stack of newspapers in the corner. It's a very odd meaning of newspapers, which doesn't point to the printed object. And remember, under the Pentonville criteria, what you're doing is comparing the genus of fact of the known state of affairs at the time of enactment, the printed object, paper with journalistic content, to the genus of fact of the new state of affairs, and asking if they're similar. And when the Supreme Court did that in Pentonville, it wasn't a difficult exercise. One known state of affairs, embryo created by fertilization. New state of affairs, embryo created by CNR. Both embryos, both in need of protection. Purpose pointed one way. You update the statute. That's not our case. You've got a printed, folded object that one can keep their fish and chips in, as my learned friend said, or leave on the tube for somebody else to read. And you've got an electronically supplied service that needs a device or an internet or whatever the other differences are, and can link into other content, can link into archived.
Well, you're hinging a lot on the physical aspect. I mean, that's I think how you explain the embryo example. But one might say, well, nobody in their right minds would have contemplated some sort of genetically engineered embryo in 1975.
My point isn't that they wouldn't have contemplated it, because all these cases and the technical innovations don't assume that it would have been in contemplation. So Parliament is never thought to have contemplated it in these cases. It's saying, given that it didn't contemplate it, how do we answer the question if this is in or out? And the Quentinville criteria is, well, ask if it's the same or similar genus of fact. Is it the same kind or dimension? Is the statute that you're interpreting one that is supposed to be interpreted liberally or one that's supposed to be interpreted restrictively? And also asks, is the purpose of the statute only achieved by including this new innovation that wasn't in Parliament's contemplation? And their lordships thought that clearly the purpose would not be achieved if these were kept out, these embryos that created by CMR, that were in nobody's contemplation. My point is, it's nothing like our case. There's no reason to think that the statutory purpose in play here would not be achieved if electronically supplied newspapers are not zero rated. Printed newspapers are readily available. We want to ensure that the public have some VAT-free access to newspaper content. It's enough that they have it in printed form.
Well, some newspapers have stopped publishing in printed form. They only supply them electronically.
Well, in the claim period, we weren't there, but just to give you a taste of how the EU feels about the argument, well, we can't have an effective zero rate if we can't do this. There is a bit in... could you just turn up Authorities, page 279. This is the case where in 88 the Commission took infraction proceedings against the UK for its zero rating, either because it didn't accept the social policy was okay, or it wasn't for the benefit of the final consumer. And you could just turn to page 297. So Group 7, Fuel and Power. Else, do you have it? So this was a Group 7 zero rate. Paragraph 30, Commission challenges the zero rating of supplies of fuel and power other than to final consumers. In its defence, the UK relies essentially on the negative effects from the social point of view of any taxation of such supplies, in particular to schools and hospitals. While the Court does not call in question the social reasons underlying that policy, it must point out that the services in question cannot be considered to be provided for the benefit of the final consumers, since final consumers, as defined above, derive only very indirect advantages from zero rating. With regard to the UK's alternative argument to the effect that the difficulties in administering the tax, if only supplies to final consumers were zero rated, would probably be insurmountable, it must be observed that where a member state wishes to take advantage of the derogations in question, must take all the practical measures necessary for the proper application of those provisions. If it considers such measures cannot be implemented, it must refrain from applying zero rates. In other words, if there is a general, and I'm not sure that there is, but presumably courts generally do their best to give some effect to legislation that hasn't been repealed. So if there is that general position, if we were in a situation where printed newspapers no longer existed, the EU's position would still be, well, tough, then don't have the zero rate. You don't have to have an effective zero rate. These are derogations that we tolerate, and we're trying to abolish step by step. And that's why, as new member states join, we still have the 1991 standstill date. So that's one answer. The key answer is we're talking about the period 2010 to 2016. There's no question that printed newspapers are obsolete or the public didn't have access to them.
You have to have some criterion, don't you, in deciding how to categorise any new object, to decide what are the essential aspects, characteristics of the object, and what are contingent characteristics.
Absolutely.
I mean, your genetically modified tomatoes, that there is a difference, but you then have to decide, is that a relevant difference? And you can only draw that distinction, can't you, by some concept of function of the object.
Perhaps not today, but tomorrow I'll make submissions on why that's wrong.
Yes.
But perhaps I can sort of try and give a headline answer in the 1 minute that remains. It depends a little on the area you're thinking about, but generally, meaning is not what's valuable in an object, not what's important in an object, and not based on the function of an object. So, in Quentinville, a paragraph I'll start off with tomorrow, paragraph 9, I think as Lord Bingham says, the always speaking doctrine can't make a dog a cat. There are limits. Of course, they're both live animals. Of course, they're both commonly used as pets, but a dog is not a cat. So, as my Lord Legate points out, you need certain criteria. And I say we all know we all know what newspapers were in 1975, and it would be very odd to define a newspaper without mentioning that it is an object made of folded sheets and so on. That would just be a wrong meaning. And I think I can appeal to our common understanding to make that good. The reason function is wrong is imagine a 0 rating of a supply of dogs for the visually impaired. To use Lord Bingham's example in Quentinville, if a dog is not a cat. So dogs for the visually impaired, supplies of dogs for the visually impaired are 0 rated. Now imagine a robotic dog for the visually impaired, and this is not far-fetched. There is, in fact, apparently at the University of Berkeley, development of a robotic dog for the visually impaired that uses sensors to assist the visually impaired in getting around. Now, they both have the same function for the visually impaired. They help the owner get around. But if a dog is not a cat, a robotic dog is certainly not a dog. Now imagine an e-dog, something else in the future, an electronically supplied dog, which isn't even an object, it's not even a robotic dog. It's some sort of app combination with my phone, something in my ear, and I, as a visually impaired person, am guided around the world. That's certainly not a dog, and yet they have the same function. So in my submission, meaning doesn't work in that way. It's not about function. I mean, it may be in some cases, depending on your statute, but here we're just working out supplies. I don't think my learned friend would dispute that anybody in 1975 defining newspaper would say it was an object. My learned friend's submission is something different. He says, under the always speaking doctrine, I can open the statute and read it as though it was enacted yesterday. What does newspaper mean today? And if, which is my learned friend's claim, newspaper today includes both printed newspaper and digital news services, then I'm in the zero rate. And I'll explain tomorrow why I say that's wrong, and that even if it's right, that's certainly an extension of the scope from 1997 to 1975. My Lords, I'm happy to go on, but I'm conscious that I think you want me to stop at 4, so...
That's fine. I think that's an appropriate place. Thank you very much. The court will now adjourn and resume tomorrow morning.